there's speech and then there's conduct. But there's also some things which have an element of both speech and conduct, speech and non-speech, you could say. The US Supreme Court addressed this in the 1968 case of United States versus O'Brien. The majority opinion was written by Chief Justice Warren, and it dealt with a man named David O'Brien who burnt his draft card, also known as a Selective Service Registration Certificate, on the steps of the South Boston courthouse. FBI agents witnessed this, and he told them that he did it because of his beliefs, and he knew he was violating federal law. So he was indicted, tried, convicted, and sentenced, and he said that he did this to get people to adopt his anti-war beliefs and to basically dislike the draft as he does. The Court of Appeals held that the law against destroying the certificate was unconstitutional. They said it furthered no valid purpose, and this made its way up to the US Supreme Court. So this is a liberal Supreme Court, the Warren Court. They're very big in favor of free speech. So what Chief Justice Warren ends up saying is, this law doesn't abridge free speech on its face. So yeah, this pro-free speech court is saying, well, this law, we don't know about it. We think it's got some upsides. It's kind of valid. So the law deals with conduct having no connection with speech. There's nothing expressive about the conduct of knowingly destroying your draft card. Chief Justice Warren compares it to a law against destroying your driver's license. So O'Brien says it's unconstitutional as applied to him. He says that what he did was speech. So just because not everyone who burns their draft card is not doing it in a way that's speech, he's saying he did it as a form of speech. And indeed, that's consistent with what he told the officers. He said, yeah, I did it to express my anti-war beliefs and to get people to adopt my anti-war, anti-draft ideology. But the Supreme Court has a response to this. They disagree. They say that we can't let limitless varieties of conduct be labeled speech whenever the person engaging in the conduct intends to express an idea. Also, even if there's speech in O'Brien's conduct, the Supreme Court has held that when speech and non-speech elements are combined in the same course of conduct or sufficiently important government interest in regulating the speech exists, we can justify incidental limitations on First Amendment freedoms. So yeah, firstly, they're saying, they don't want to open Pandora's box to a bunch of stuff being labeled speech just because it can be speech. So there's a lot of conduct that might not normally be considered speech, but just because it can be considered speech in some way doesn't mean that they're going to consider it speech broadly. And then they also say, look, if the limitations on speech are incidental and it happens to have just a little bit of speech in it, or half speech, half non-speech, the law can still win the day because it's backed by a substantial government interest and it's not restricting more speech than is necessary. So they say it's sufficiently justified if it furthers a substantial government interest and is unrelated to suppressing speech, and if the incidental speech restriction is no greater than essential to furtherance of that interest. They say this law passes the test. They say that under the necessary and proper clause, Congress can establish a system of registration for people liable for training and service and may require such individuals within reason to cooperate in the registration system. That's the draft. Within reason, they emphasize, not anything unreasonable, but yeah, this was reasonable. It's just draft cards. So they say the continuing availability of each registrant of his selective service certificates substantially furthers a smooth and proper function of the system that Congress has established to raise armies, and that the amendment specifically protects this interest. So there's a substantial interest here. This law also wasn't passed with the motive of suppressing speech, and they're hesitant to say, there's a motive here, because they say inquiring into the motives of Congress is hazardous territory, and they don't think that they should strike it down just based on speculation of their motive. So yeah, it's a big W for the government in this one. Justice Harlan, John Marshall Harlan, fairly conservative guy, concurs. He says, incidental restrictions on speech furthering a substantial interest that have the effect of entirely preventing speakers from reaching a significant audience they couldn't otherwise communicate with are a bit different. He says that they can be successfully challenged under the First Amendment, but this is not one of those cases, so he agrees with the outcome, but he just wanted to chime in this concurrence with what he thought was a necessary thing to add. And then we have a dissent by Justice William O. Douglas, who's a free speech absolutist. He says that action is often expression under the First Amendment anyhow, and he adds that the main issue here is not so much free speech. The main issue actually is whether the draft is allowed with no declaration of war by Congress. Congress has not declared war in a very long time. We have to go back to World War II. So yeah, he was not really focusing on it that much as a First Amendment case. So this is a really, really interesting case because it kind of starts the concept of content neutrality. There's content-based laws which target speech based on the message, the communicative impact of it. And then content neutral stuff, which is like, yeah, no matter what you're saying, we're still proscribing it. You can't do it. No matter how you intended it to be, speech or not speech, what message you intended to communicate. And this is a really important thing in the modern First Amendment doctrine, and cases frequently reference content-based or content neutral, and whether or not a law survives is often based on whether or not that law is deemed content neutral or content-based by the Supreme Court. If it's content-based, they're going to subject it to strict scrutiny, and if it's content neutral, they're going to subject it to intermediate scrutiny. And that's what happened in this case, even though they never really used the term intermediate scrutiny. They said there's a substantial government interest here being furthered. It's not invading more speech than is necessary to further that interest. And yeah, it's tailored to that interest. So it's good. It passes. Let me know what you think about this case in the comments below. It's a really interesting one. I hope that this was helpful for you. I know I was familiar with this case all the way back in high school. So if you're in high school learning First Amendment, I hope this was helpful. Same with undergrad, or if you're in law school taking a First Amendment class, I hope that this video allows you to get an A+ in your First Amendment class. Like, comment, or subscribe to the channel. Thank you so much for watching, and I look forward to speaking to you in my next video.